Well, happy Friday, everyone. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our Advisors Forum webinar today, a discussion regarding the theory and mechanics of asset alignment in estate planning, as well as an update about document execution in the age of COVID-19 and how clients are being affected. So how this will work today, you are on mute. However, if you have a question, please pose them during the presentation, and I, as the moderator, will work with the presenters to pause periodically to answer them, as well as leave time at the end for Q&A. You received the presentation by email this morning from me for your convenience to take notes on it if you wish. And everyone also will receive a brief survey immediately after the presentation. And we ask that you do take just a couple minutes to fill out this information, offer us your valuable feedback about the presentation. For certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. If I don't have it already for my records and per the requirements of the CFP Board of Standards, please email me your ID number, and specifically for CFPs, the last 4 digits of your Social Security number as soon as possible. So we do have, this is our typical advisors forum. We do have some clients on here as well, so we want to welcome them as well. We have 3 presenters from Elville and Associates today, and they are in order: Stephen Elville, President and Principal Attorney; Mary Guay Kramer, Executive Legal Administrator and Asset Alignment Coordinator; and Nicole Livingston, Partner and Senior Estate Planning Attorney. So in the interest of time, I did email you their backgrounds and credentials earlier, but I do briefly wish to share an overview of our firm, though, for those of you who are not too familiar with us. I do want to start off by saying that our firm's attorneys and staff members work every day with the ideals of client education, collaboration, and compassion in mind. And you should expect nothing less from us anytime that you partner with us. And we do look forward to working with you, whether you're an advisor, existing client, or someone considering Elville and Associates for the first time. So I'm going to take a minute just to share my screen and talk a little bit about our firm for just a minute. We were founded in 2010 in Columbia by Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, guardianship and litigation, as well as a focus in asset protection and tax planning. We have 7 attorneys, 13 staff members in 5 locations, and we're coming to you live here from our Columbia location in the busy Columbia Gateway community right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We focus a lot on education here at the firm, and we do that through many different means, through planning processes with our clients, through over 100 educational webinars and workshops in the communities that we serve each year, and by way of our accredited client care program through the Client Care Academy in Boston. And we are one of only 60 law firms in the country and the sole one in Maryland with that accreditation. So if you want to learn more about that, please reach out to myself or Mary Guay Kramer, who is the Client Care Program Coordinator, and her information is going to be at the end of the presentation today. So without further ado, I'm going to go ahead and get started with the presentation. We do have a brief poll that we want to start off with, just to get an idea of how familiar you are with asset alignment. So I'm going to go ahead and launch that poll. And the question is, how familiar are you with the process of asset alignment in estate planning? So I'm going to go ahead and launch that poll. And the choices are: I am very familiar with and have gone through the process before. I went through this process before, but found it very confusing. The entire idea of asset alignment is new to me. Or lastly, I think I may have a plan that should have this in place. So choose your best answer. It is anonymous. We appreciate you participating. We have half the votes in. We'll give it a few more seconds. Okay, so the responses are in, and the tallies are 40% saying, I am very familiar and have gone through this process before. 20% saying, I went through this process before, but found it very confusing. 30% saying the entire idea of asset alignment is new to me, find that interesting. And 10% saying, I think I may have a plan that should have this process in place. So thank you for participating. We appreciate it. That's good insight for us. I'm going to go ahead and close this out, and I'm going to go ahead and turn the reins over to Mr. Stephen Elville. So I'm going to change presenters and give it to Steve. I'm going to turn my camera off so I'm not a distraction. And Steve, you should see that turned over to you.
Thank you very much, Jeff. Yes, I see it, and I'm going to just ask you now, do you see it, Jeff? And am I able to manipulate the screen? I believe I am. All right, well, thank you, Jeff, for that great introduction, and good afternoon to everyone who's in attendance. We appreciate you taking the time on this Friday afternoon to spend time with us for our advisor forum. It's a pretty overcast day here in Columbia, Maryland, but hopefully the sun will peek through soon, and I hope you have a wonderful weekend ahead. So as we start off the fall season of the advisor forum, we're starting off today with fundamentals. We're really drilling down to the very, very basics of asset alignment. And you're very, very lucky today because I have presenting with me two real powerhouses. My executive assistant, Guay Kramer, who is a very much a powerhouse in her own right in her administrative and executive administration role. And my partner, Nicole Livingston, who is just an incredible workhorse, estate planning phenomenon person who has simply just gotten the job done for our clients since she has been part of our firm. And over the last 6 months with COVID-19 and all the challenges, has provided enormous value for all of us in helping us help our clients through the crisis. So I'm very privileged to have Nicole coming in here at the end of our presentation to talk about the mechanics of what's going on to actually get clients through the planning process for signings and all of those challenging things with COVID-19. So I'm really happy that Nicole is here. Our next advisor forum in November is going to really hit hard at the end of the year issues. So year-end issues that many people are worried about, the elections, changes, potential changes in the tax laws. What should we be planning for and looking for at year end? I know many of you are worried about this. I want to assure you that I'm not hearing anything earth-shattering right now about the end of the year, but obviously there's a lot of unrest in the country. There's a lot of political unrest and uncertainty, and I know many of you are worried about those issues. So we're going to address that in our advisor forum in November. So with that said, I'm going to get started, and remember this is a free-flowing discussion. I'm going to be pausing a few times to ask Jeff if there are any questions from the audience, but otherwise we're just going to plow ahead, and it's a privilege to bring the education to you today. So what is asset alignment? So first of all, let's talk about definitions. One of the things that I think I'm guilty of calling this process funding. We call it funding instead of asset alignment. So I think the term funding, some people understand what that is, having an estate plan and then funding that estate plan with assets or properly having those assets go through the plan. But I think a more accurate term is asset alignment. So asset alignment is really structuring the assets in coordination with an estate plan. So if we have a will plan, which I want to talk about in a minute, we still have some asset alignment. Many people think there is no asset alignment in a will plan, but we think there is. Asset alignment in a revocable trust, asset alignment in an irrevocable trust. We are structuring assets to flow in accordance with the person's wishes and in accordance with the flow of how that plan is supposed to work. So we'll talk about that. So arguably, this is the most important thing in estate planning. And so we see examples of this on a weekly basis. We have competitor firms where we have clients come in consistently from other firms, for example, and we look at their plans and they have a set of documents, arguably nothing wrong with those documents in many cases, but the documents are not supported by the asset alignment. So it's not uncommon to have clients come in, and I know the advisors on the call have this same issue, to have clients come in and you find out that they have not heard from their estate planning firm for 5 years, 7 years, 15 years, and there's nothing aligned in the estate. So arguably, as we look at the second bullet point here, how we own our assets at the time of our deaths is really the only thing that matters. We could actually argue that how the assets are owned at the time of death is more important than the documents themselves. Although obviously the aligned assets and the documents have to work in coordination. So I think that for all of us individually and for all of us on behalf of our clients, and I know there are some clients on the call, as well as advisors, we have to think in terms of 10 years from now, 5 years from now, 25 years from now. At some time in the future, at some unknown time when we are deceased, whenever that may be, wherever that may be, how will our assets be owned at the time of our death? That is probably the number one question. And that question goes to the heart of asset alignment. So whether we call it funding or whether we call it asset alignment, this is normally associated with revocable living trusts. And remember, revocable living trusts are nothing more than substitutes for wills. So if we have a will substitute, we have a shell, we have a document, we have a structure, and that structure has to be filled with assets. And the assets that don't go into that trust, which we're going to talk about in just a moment, those assets are going to remain on the outside of the trust, and they're going to need to flow by some form of beneficiary designation. So asset alignment is normally associated with trust, but it is also associated with irrevocable trusts, whether these are irrevocable trusts during life, where someone created an irrevocable trust for a child or a niece or nephew or grandchild. That trust has to be funded with assets at some point during life or at death, whether it's a special needs trust, whether it's a charitable trust, whether it is a life insurance trust. Making sure those assets flow is part of advanced estate planning, not just basic estate planning, where we are dealing with basic revocable trust plans that are substitutes for a will. And then you'll see, I mentioned earlier, wills. We don't want to forget about the fact that many lawyers will draft wills and then they just have the client sign the wills and that's it. Well, that's not getting the job done because we have some asset alignment to do with the wills. What if the wills are providing, which many of them do, what if they provide for minor children? Well, we have to make sure life insurance is flowing to the trusts for children. So we want to make sure that the beneficiary designations for the testator are aligned properly. We want to make sure that if there are retirement plans that are going to go to trusts under a will, and we have some challenges there, we want to make sure those are properly aligned as well. So wills have to have asset alignment for beneficiary designated assets. Many times wills will be structured in a complex way. This is not so common these days in our practice, but a will could provide asset protection for a surviving spouse, or a will could provide a trust for a surviving spouse for marital protection. But what if there's no assets flowing to that trust? So how assets are owned in that particular situation is complex, and it has to be addressed or that will is not going to work properly. So moving assets into alignment with the estate planning structure, whatever that is, whether it's a revocable trust, an irrevocable trust, or wills. This is very, very important. And where someone does not use a will or trust, we are still concerned about how are assets going to flow. I met with a couple recently who are going to use wills, and they're not going to use revocable trusts. And what they're going to do is have assets flow outside of probate in addition to having a will for certain assets. So that's a unique situation, but we want to make sure whatever the structure is, that assets are flowing properly through the plan. All right, I'm going to go to the next slide now. So when does asset alignment occur? And again, for those of you who think of this in terms of funding, when does funding and asset alignment occur? Well, ideally, this is going to want to occur at the time of the document signing. You know, it's hard enough to focus on getting one's estate plan in place. It's hard enough to focus on getting an estate plan updated over time without having to worry about, well, how am I going to deal with asset alignment after I sign my document? So the ideal time is to sign the documents and also have as many of the asset alignment forms or deeds or whatever the documents are ready to sign at that time. But many times there is a situation where we are not able to have all the documents signed at the time of signing, although that is the ideal thing to do. So I would say that in a perfect world, asset alignment is going to occur during the signing and during the post-signing time of 60 to 90 days after someone signs their documents. Now, there are times when someone's traveling overseas, or there's an urgent situation, there is a health situation, or an end-of-life situation where asset alignment has to occur right away. There has to be a beneficiary designation signed right away. It's got to be faxed right away. It's got to be processed. A deed has to be recorded. But generally speaking, under non-emergency circumstances, we want to do as much as we can at the time of signing and within 60 to 90 days, preferably 60, after someone signs their documents, whether it's a will or a trust. Now, during lifetime, and we're going to talk about this more during the presentation, we want continuing review and updating. So new assets are acquired during life. Lots of things can happen over the years. And those of you who have been on these webinars before, and those of you who know the statistics, know that about 55 or 60% of people across the United States have no planning at all, or their planning has really fallen by the wayside. So that means a minority of people, only about 45 to 50% at the most of people at peak ages have planning. And of the people who do plan, it's a good reminder to know that it's about 19 or 20 years at a time between times that they do planning, and this is the minority of people, and they update their planning. So most people are lucky to have an estate plan, and they should be commended. If you have an estate plan on this call, you should be commended. But most people don't do a good job of updating. So if we're not doing a good job of updating, which we're going to talk about a little bit later, then the asset alignment is even more important at the time of signing and within 60 days after the signing. But during life, the continuing updating should also not only address legal issues, but it should address asset alignment issues. All right, let's take a few moments just to review the real fundamentals of the types of assets. And this list that I'm going to talk about is not all inclusive, and there might be certain types of specialty assets. Let's just talk about the different types of assets. Well, let's start with tangible personal property, furniture, belongings, and jewelry. Well, in a revocable trust plan, these assets are aligned by signing an assignment of tangible personal property. Now, with a will plan, we're not worried about assigning tangible personal property because wills go through probate. Assets like tangible personal property go through probate, whether we have a will or whether we don't. But for a revocable trust, we're going to assign those assets. Now, there are things like intangible items of property, notes and receivables, or royalties. Those kinds of things are assigned as well to a revocable trust, but not to a will. So revocable trust has a couple of extra types of assets that can be assigned to it, tangible and intangible property. But now I'll just go through a very common list of what I would call non-retirement assets. If we think about the types of assets, I would break them down into retirement assets and non-retirement assets. So non-retirement assets in my mind include stocks, bonds, mutual funds, brokerage accounts. These things should be retitled in a revocable trust, but they are not retitled in a will. So a will, for those of you who are confused about this, with wills, we do not have to retitle assets, generally speaking. Now, with more complex wills, like the mention I briefly alluded to earlier of a complex will between spouses, which is not commonly done in our practice today for various reasons, which are too much to get into today, we would actually separate assets and retitle assets in the name of each spouse. But generally speaking, for wills, we are not retitling assets unless we absolutely need to for some reason. We are talking about retitling non-retirement assets inside of a revocable living trust. Let's talk about that for just a second. Those of you who understand this know that a revocable trust is ignored by Uncle Sam because it is a grantor trust. It is a trust that is identified by the grantor's social security number. So Uncle Sam doesn't care that you have retitled your assets inside of a revocable trust because the tax reporting is the same. Checking and savings ideally should be in the revocable trust if we have a revocable trust. In a perfect world, money market accounts should also be retitled in a revocable trust. So that's part of funding and alignment. If we have wills, checking, savings, money markets would typically not be changed unless we made a payable on death designation or a transferable on death designation for a money market account. And I'm going to talk about challenges with that. CDs, certificates of deposit, would either remain the same in the name of the testator, or if we have a revocable living trust, we would retitle the CDs in that trust. Now, what are we worried about there? Many times CDs have a life of their own, and it might be 6 months, 3 months, it might be 3 years, and we don't want to lose interest or have a penalty. So generally speaking, that's going to be a decision at the time of the signing of a revocable trust. Do I want to move my CDs at the risk of a penalty? Many times it's worth it, sometimes it's not, and yet that is a follow-up item because we don't want to say, okay, let's not put it into the trust, and now 9 months later we've forgotten about it and it's hanging out there outside of the trust. So CDs go in there. Savings bonds. Many people are not aware that savings bonds that are in the name of the person who is making the will or trust, those savings bonds are subject to probate if they do not have a joint owner or if they don't have a payable on death beneficiary. So savings bonds these days are not as popular as they used to be, I don't think, but there's still many savings bonds out there. Some people have more than others, and those in a revocable trust need to be retitled. This is pretty straightforward. We get a photocopy of the bonds, we send physical bonds to Treasury Direct, and now they do not reissue physical bonds, has been my experience, and you have a titled account with an account number instead of actually having your physical bond. So I know many of you and many people love their bonds, but you do not have to hold them physically, but they should be titled in the name of a trust. If there is no revocable trust, then they can just remain in the sole name of the person who owns them. And if there's no beneficiary, they will go through probate. Business interests should be aligned with the estate plan. So someone who has an LLC, a limited liability company, and if that LLC is owned by that person and that person has a will, that LLC is going to go through probate, just like everything else that's subject to probate. If a person has a revocable living trust, their LLC, depending on the operating agreement and the complexity of that LLC can be assigned to the revocable trust, and the revocable trust becomes a member of the LLC, and therefore at death, the LLC flows by way of the revocable trust, and there is no probate. Corporate interests, such as S corporations or other corporations, they can either be made transferable on death to someone or a trust, or the stock certificates in a corporation can be retitled in the name of a trust. But my point there is that we have to address those types of business interests as part of asset alignment. Real estate has to be titled either in the name of the person who has a will and it's going to pass by probate, or real estate could be titled as a life estate with power of sale, where it automatically goes to the remainder beneficiaries with no probate, or a life estate with no power of sale, which is a Medicaid technique to those remainder beneficiaries. Or if we have a revocable trust, residential real estate should be titled in the name of that revocable trust by deed. And we're going to talk a little bit more about husband and wife ownership for those of you on the call who are married. Now I'm going to switch to retirement assets and just say that IRAs are beneficiary designated, obviously, 401ks, 403bs, 457 plans, qualified plans, they're beneficiary designated. Now, why is it critical to have a beneficiary designation? That's because if we don't, we're going to suffer tremendous taxation of the qualified plan or IRA going through probate. So we don't want to accelerate taxation after all those years. These are non-Roths now, all those years of saving, okay? And annuities, of course, annuities can be qualified. So that means they can be an IRA annuity, let's say, or a non-qualified annuity. Retracing my steps for just a second to what I would just call non-retirement assets, quasi-non-retirement assets. A non-qualified annuity could be owned by a revocable trust, or it could be beneficiary designated to a revocable trust. So with non-qualified annuities, we have a little bit of flexibility, but with IRA annuities, we are just simply, from an estate planning point of view, we're dealing with IRAs. So IRA assets have to flow properly. So if we have a revocable living trust, we can leave the IRA money through the trust if it is a quote see-through trust, or more preferable in our practice, we leave IRA beneficiaries designated directly to beneficiaries, or many times directly beneficiary designated to trusts for the beneficiary, so that beneficiary can have spendthrift protection in the inherited IRA. For trusts for spouses, we might beneficiary designate an IRA directly to a trust for a spouse. So we have to address how these assets are going to flow between spouses and then down to the beneficiaries or trusts for the beneficiaries. So what I want to do now is transition into a different phase of the discussion and talk about challenges that are related to beneficiary designated assets. And we were just talking about those, IRAs, annuities, 401ks, and qualified plans. So challenges, let's talk about those. Well, the forms in general are challenging. There are forms that are accepted by certain financial institutions, and there are forms that aren't. For example, if we have a very simple beneficiary designation to an individual, this is not going to be a big deal. But if we have a more complex beneficiary designation to a trust or a trust for a spouse, and we have some verbose language, then that beneficiary form might be challenging to get it accepted. So we have some challenges with the forms themselves. So we have to take that case by case, and this is where Mary is very strong. Trusts under wills. Trusts under wills in general, I have seen in the last year and a half some difficulty, and I want to make sure I'm being very clear here, some difficulty beneficiary designating IRAs and 401ks to trusts established under wills. So if we run into that problem, which we've occasionally run into recently, where the custodian refuses to accept the beneficiary designation of a trust being the recipient of an IRA or 401k under a will. We would either switch custodians and change companies, or we would change from a will to a trust, because generally speaking, I have not seen problems with beneficiary designating an IRA to a trust under a revocable trust. So that's one of the challenges. Now, asset protection for IRAs, beneficiary designated IRAs. There are asset protection features for you during your life, for your 401k, for your IRA, those are asset protected. But inherited IRAs that we leave our children, grandchildren, or others, IRAs at our death for beneficiaries, those are not beneficiary creditor protected, I should say, for that beneficiary, unless we use a trust. So that's a challenge with beneficiary designated assets. Life insurance, we can drive life insurance anywhere we want. We can drive it to individuals. We can drive it through the funnel of a revocable trust. We can drive it down to a trust for further beneficiaries. So not a whole lot of problems there with beneficiary designating assets like life insurance as much as IRAs. But we do have issues with taxation, and this is back to IRAs now. This is an issue that's not directly related to asset alignment, but it's indirectly related. So if we say we are driving an IRA into a trust for someone, and that person is not exempt, they are a healthy individual that's going to receive that IRA, and the most they can stretch that IRA out is not their lifetime, but 10 years, because they are not exempt under the Secure Act, then we have a little bit of a challenge there, because we've created a lot of taxation by having that IRA come into certain types of trusts that we would recommend for beneficiaries. So those are challenges related to beneficiary designated assets, not only where they're flowing and making sure beneficiary forms are properly filled out, but the taxation that's caused once we've made that decision. The bottom line is we don't want to leave beneficiary designated assets like IRAs or 401ks with no beneficiary. This doesn't happen very often, but at least once a year, I have an occasion in the conference room where someone, whether they're single or married, will admit to me that their very large IRA has no beneficiary designation. So we don't want that to happen, and that's why follow-up and asset alignment is very, very important. The last bullet point on this slide here talks about inherited IRAs and special needs trusts. Many people in asset alignment or funding will say, Steve, those IRAs that I have now, those go into the revocable trust, right? And the answer is no. We cannot retitle during your life. We cannot retitle an IRA into a revocable living trust or any trust without triggering taxation. So I'm going to say that again. IRAs during our lifetimes cannot be owned by a trust, even a revocable trust, without triggering all taxation. You would be very unhappy. But when we pass away, we can leave IRAs to a trust to protect our beneficiaries or protect our spouse or children, whoever that may be. But let's say that a special needs individual, a person with disabilities, receives an inherited IRA, and obviously they should not have received that IRA. They received it outright. It was not left in a special needs trust. It was left to that person outright. The IRS, Uncle Sam, has provided a way through many private letter rulings to be able to move the inherited IRA of a person with disabilities from that person into a first-party special needs trust, which we don't need to get into all the details of today, without triggering taxation. So Uncle Sam has allowed one situation and one situation only that I'm aware of where a beneficiary of an inherited IRA can move that inherited IRA into a special needs trust with no taxation. So that's just something to always remember, since so many of us have friends or relatives who have disabilities these days. All right, so that's a lot of information just in about a half hour. I'm going to stop for just a second and ask Jeff, are there any questions?
Steve, Don't have any questions at this time.
All right.
Everybody, we do encourage questions, so please don't be shy.
All righty. Get your questions ready for Mary and Nicole because they're the powerhouses here. All right. I'm now going to advance the slide to risks associated with asset alignment. Now, the list that I've made here is not all inclusive, and I'm going to add a few things to this list. But I just want to say that joint ownership is a risk. Now, when I say risks associated with asset alignment, probably a more accurate thing to say is risks associated with the failure of asset alignment. So I apologize. I probably should have said with the failure of asset alignment, but I think you understand what I'm saying. So when we have joint ownership, we have a situation, obviously, where it's a savings account, money market account, brokerage account. This account passes by operation of law to the survivor. Now, when I say survivor, the surviving joint owner. Now, let's say the person who passed away, the deceased joint owner, has this wonderful estate plan, but they have plans for that estate plan. They have a trust for a spouse, let's say, a trust for a special needs child, a trust for a problem beneficiary, or some kind of a special provision. But look what happened. The jointly owned asset passed to the surviving joint owner, and the documents did not control. So that is a risk for joint ownership. Another risk is really creditor problems. So let's say that we intended to change a jointly owned asset, but we overlooked it somehow, or we didn't know about it, or there was no follow-up, and now we have people owning property jointly. How many of you know someone who says, hey, I'm 60 or 70 years of age or older, and all of my assets are owned with my 3 kids? Well, now that's a problem, because if it's significant assets that are owned that way, now that person has opened up themselves to the risks of the claims of creditors of their children. Divorce, car accidents, bankruptcy. They have put their own assets, even their residence, they have put those assets at risk. So there are all kinds of risks associated with joint ownership. But I'm going to bring up something now, if you're writing this down: failure of tenants by the entirety's ownership. So remember, joint ownership for spouses really should be husband and wife, tenants by the entireties. Now, if you're married, you can own property jointly. It does not have to be labeled as tenants by the entirety's property. But we know that since around 2012 in Maryland, tenants by the entirety's property can be owned within a trust. So first of all, if you're married, or if you have clients that are married, and those people have a joint brokerage account, but it is not titled as husband and wife, first of all, that should be changed. If you're an advisor, that should be changed. I have met people, including my own doctor, who said that, hey, I've got this pretty big brokerage account, and are you kidding me, Steve? I could have owned this not as a joint owner, but as husband and wife, or spousal ownership, I should say, as tenants by the entireties. Yes, the answer is yes, and most financial advisors are not addressing that issue. So that is something that both clients and advisors need to address. Now, if you have a revocable living trust, and we move that husband and wife property into the trust after it is owned as husband and wife, the new law says that you continue to own those assets and have the basic protection of husband and wife, tenants by the entireties, even after it flows into the trust. So that did not used to be the case when I was a young lawyer many years ago, and now that's something we want to take care of. That is a cleanup item for many people, to go back and own assets as husband and wife if you're married. I'm sorry if you're not married. And then to redesignate or retitle that husband and wife property into a revocable trust if you have a revocable trust, and it will retain its creditor or asset protection status as tenants by the entireties. So that's something we want to do for brokerage accounts, for real estate, and so forth. We don't want to miss that. Failure of spendthrift protection. So obviously, if assets are flowing to a joint owner, or they're flowing outright to someone, or they're flowing to an estate when we did not intend to do that because we do not have our beneficiary designations correct, or we do not have our titling correct. Now, the spendthrift protection in a further trust that we could have provided for the beneficiary, that spendthrift protection is lost. And we can't go backwards to fix that, generally speaking. So this is something that's very serious, the failure of protection of beneficiaries where we have left trusts. Medicaid recovery. So I just want to talk about two things here. Let's talk about something that's a little bit of an offshoot of what we're discussing today. Let's say somebody is a married person and they are concerned about nursing home costs, and they actually have to do a Medicaid spend down. This is where titling, and this is where how you own your assets is critical. I've met many spouses who had to put their ill spouse into a skilled nursing home, and under the Medicaid laws, you have 90 days to take all assets out of the name of the ill spouse. And I've seen many people who were not properly advised, and 2 years later, 3 years later, they still own their house jointly with their ill spouse, and they had a 90-day grace period to get that property out of the ill spouse's name, and it was not done. So that is a big problem for Medicaid recovery. Now, many of you have heard me talk about the new law, the new elective share law, and if you don't know what that is, we'll talk about that on another webinar. But there is a possibility between spouses to protect all assets. So with regard to Medicaid recovery, if one spouse owns all the assets in his or her name, and this is the well spouse, because we've done planning and we've moved a lot of assets to the well spouse's name. Well, if those assets are properly aligned and funded into a further trust at the death of the well spouse, if we do that, and it's unlikely that the well spouse is going to die first, but if we make sure that the assets are aligned properly, then there's going to be no Medicaid recovery in Maryland based on the new elective share law, which has to do with protecting spouses, but it also has to do with a Medicaid recovery element. Unwanted probate. So obviously, people who want to avoid probate are either going to use a revocable living trust and have that completely properly funded with assets, including proper beneficiary designations. And if we don't do that, we have a revocable living trust plan that's not properly funded, and we have unwanted probate. So the plan has failed. We have the assets in the trust that are being administered, and we have an unnecessary probate estate. So we don't want that. What if there are problems with beneficiaries? I should have said challenged beneficiaries, and I apologize about that. This should say challenged, not problem beneficiaries. What if we have beneficiaries with special needs, or these people are vulnerable but high functioning but very vulnerable? Or what if they have mental illness? Or what if they have substance abuse? We have to be very careful about how assets are flowing down to trusts for these individuals. For example, let's say we have a special needs beneficiary or a person with chronic illness. They are using a special needs trust, or what we call a supplemental needs trust, for that's going to receive the money for them. And remember, because they are not well, they are exempt under the Secure Act. So if IRAs or 401ks are left to the special needs trust or supplemental needs trust, that person can continue to stretch out the taxation forever throughout their entire actuarial life expectancy. So if we don't have the assets aligned properly, we're going to ruin that and mess that up. Now, problem family members. There are cases, and many of you advisors have seen this, and many families have experienced this, where we have challenges with disinheriting a particular child and possibly having a will challenge. So let's talk about why funding and alignment is so important here. If we have a family situation like that, it's essential that usually, not always, we're going to use a revocable living trust. And if we're using a revocable living trust to take the estate plan out of probate. And why would we do that? Because in probate court, or in the Register of Wills Orphans Court, we call it, the will is very easily challenged. Whereas if we take that estate plan out of the will, out of the probate context, it can still be challenged in the circuit court if it's a revocable living trust, but it has to go through the formal rules of evidence. The person who is challenging it is going to be subject to the circuit court's jurisdiction over trusts. And so it's going to be more difficult, in my opinion, for that person to challenge. They can still do it, but it will be more difficult. So now, if our asset alignment is not proper, if our asset alignment is askewed and assets are flowing into probate and part of them are flowing non-probate, now we've opened the door, in my mind, for the problem beneficiary to be able to challenge a will. Because remember, in a revocable trust, assets that are not in the trust that should have been in the trust are going to be swept up by the pour over will or the backup will, and that's going to go through probate. So now the door to at least cause trouble. I'm not saying the person is going to win the case or overturn the trust. I'm just saying they now will be able to be in probate court, finding out information, doing all kinds of things that you did not want them to be able to do. So that's a problem. That leads me to malpractice. I think malpractice potentially for attorneys, malpractice potentially for other advisors to not have or not making sure that clients' assets are properly aligned. So I just wanted to say that is a concern on a professional level, and as a best practice, assets have to be aligned. Oversimplistic approaches, I'm going to say, transferable on death. I know many financial advisors advise their clients, maybe not those on this call, but many advisors advise their clients to just avoid probate by leaving all assets transferable on death directly to beneficiaries. And clients will go to banks and other institutions and say, listen, I just want to make this money payable on death at a bank to my beneficiaries. Now, there's nothing wrong with this in theory. It's a perfectly valid approach, except it is not the preferred approach. We generally in estate planning want to see assets either going through a will or going through a revocable trust so that the person who's creating the trust or the testator under a will can actually control the flow of assets down to their beneficiaries without unexpected results. If a beneficiary is deceased, heaven forbid, we know that through a will or trust, the asset will flow in the way that the person says it should flow. Whereas if we have unexpected events that occur with a TOD transfer, or if we have a dispute in the family at the time of a TOD transfer, assets can be frozen, or assets in the first example where we have an unexpected event, like the order of deaths is not what we expect it to be, assets could flow in a way that we don't expect. So the oversimplistic approaches we discourage, and we encourage people to only use those where it really makes sense. And now I'm going to move ahead real quickly to allow plenty of time for Mary and Nicole to speak.
Steve,
I'm going to talk.
Yes,
Jeff, do we have
just a couple related questions, please? Thank you. So one question we have is a special needs trust protected from Medicaid recovery?
All right, that's a great question. And the answer is generally yes. So there are two types of special needs trusts. There is what is called the third party trust. This is the trust where someone like yourself passes away and leaves assets to a trust for a special needs beneficiary. That trust, because the money is coming from you and not going directly to the beneficiary, but going into a trust for the beneficiary, that trust is exempt for all means tested purposes, SSI, Medicaid, the waiver programs, and so forth. Now, there's a first party trust. This is where the beneficiary has received assets they should not have received. So let's say the plan failed, or someone just well-meaning person left somebody $200,000 of assets that has special needs. And we've seen that many times. If that person is under 65, there is a way to put that money into what is called a first party trust. And there is a payback to the state of Maryland if there's any money left in that first party trust at the death of the beneficiary. In the third party trust, which is what we encourage as far as basic planning for special needs, there is no Medicaid recovery. So first of all, the trust protects the benefits of the person, and there's no recovery at the death of the person. In the example of the first party trust, the trust protects the person's benefits, so it gets the money out of that person's name, but there is a Medicaid recovery on the end of that when that person passes away, if there's any money in that trust. For persons over 65, there is what is called a first party pooled trust, and there is Medicaid recovery, generally speaking, at the death of the beneficiary for a pooled trust. Sorry for the long explanation.
Thank you, Steve. And one more. How do you title a real property that is only half owned?
That's a great question. So it depends on whether we're talking about spouses or non-spouse joint owners. And it depends on the situation, honestly, about what are we trying to accomplish there. Remember, all planning is goal-driven, situation-driven. It's possible to take that 1/2 interest and say, well, I'm taking that 1/2 and putting it into my own revocable trust. So I'm controlling 1/2. Whereas in another case, we might not do that. So it is possible, depending on whether it's an elder law concern or just a general planning concern, and the relationships between the people and what is trying to be accomplished is a counseling issue. So that's going to be a question of facts and circumstances.
Thank you, Steve. That's it for now.
All right, thank you. And as we get into the portion here where I'm getting ready to turn over the reins to Mary and Nicole, I just want to say, how do we avoid plan failure with all this discussion of asset alignment? Well, the only way I know is to get back to the fundamentals where we are updating and reviewing on a regular basis. Now, if you're 40 years old, I would say you're doing great if you even have a plan, because 80% of people under age 45 have no plan. So if you even have a plan and you're only 40, if you update every 5 years, you're doing great. You're providing for guardians for minor children. You're doing all the things that you should do for those minor children. If you're older than 45 or 50 or 60, I say we want to update every 2 years, 3 years at the outset, and ideally we would want to spend at least an hour together every year just to make sure we're covering all the bases. Are there any new assets? Have people changed addresses that we've listed in our plan? Have we updated our asset alignment from the first go round? Did we make sure that everything was done? So let's look at this avoiding plan failure. Our firm has a client care program. It's the only accredited client care program in Maryland by the Client Care Academy out of Boston, Massachusetts. We were privileged to be trained by a gentleman named Benny Bonazzoli, and Benny is he's not in organized crime, I promise you. He's a wonderful man who's an elder law attorney in Massachusetts. And we've developed this plan over the years, and we charge $850 a year for this plan. We have 4 major educational events per year. One of them is a social event, and it's to encourage people to update. That's really the thrust of the program. We give people 2 hours of discounted attorney time per year, but the whole thrust of it is really not about the money. It is about encouraging people to update over time, because we know that if we do that over time, the asset alignment will take care of itself. And so with that said, I'm going to go to the next slide, which I'm going to turn it over now to my wonderful assistant, Mary. Mary is going to come over here and get in front of the camera. And Mary's going to talk about asset alignment, her process, just to give you a flavor for this, and what she does that is so important with just the relentless follow-up with clients. One of the things I will mention as I turn it over to Mary is ultimately there are ethics opinions that say lawyers are not responsible for client asset alignment. but we want to make sure that we are doing our part to make sure that the client is doing what they're supposed to do, and as a team, in a coordinated effort, we're getting people's assets aligned. But ultimately, the responsibility is the client's, but a highest and best practice we feel is to make sure that we are hands-on involved, and that's what Mary's going to talk about. Thank you, Mary. Come on over and talk.
Hello, I am Mary Guay Kramer, and I just want to discuss what my process and my role is as part of Asset Alignment Coordinator. So what I basically do from the time a client is welcomed into our firm is I will work very closely with the client as well as their financial advising team to obtain their asset information. This asset information is contained, the form for it is contained in our questionnaire. They can either fill out the questionnaire fully, or they can simply provide me with most current statements for their assets, meaning bank accounts, non-retirement investment accounts, declaration pages for their life insurance, and retirement accounts. And with this information, I will build my first asset spreadsheet, which is a beautiful Excel spreadsheet, which is color coordinated for everyone's viewing pleasure. And that will help the attorney determine the best plan and the best topics of conversation, I guess, so to speak, to go over with the client regarding how much asset they have. So once you have your plan in place and you have decided whether it'll be a trust, a revocable trust plan, or a will-based plan, once I have that information and I know the direction that your plan is going, then I can start working towards the end game, which is making sure that your assets are protected from probate. So I will work with you, the client, and their whole financial team to make sure that once the documents are signed, we move into that phase where you will sign your forms to either retitle your accounts to your revocable trust or to beneficiary designate them to a will-based plan or a revocable trust plan. Everything is usually very straightforward, and I can communicate directly with the financial advisors. I like to meet them first, either virtually or by phone, so that they know who's asking for all this personal information. And then my goal is to have all of this information, all of these forms ready at the time you sign your final documents. Right now, since we're doing a lot of remote signing, that's always not the case. So if I can have it done at that point, or we can't meet because we're doing this all remotely and those cannot be remotely signed, then I will work with you directly to either mail out the forms or meet you separately. And once everything is signed and either the financial advising team takes control of it, all the assets that are under their management can be handled directly by them. Or if I'm having forms signed and returned to me, then I send them out for processing, and I have you follow up with the companies to make sure that you've received your confirmations. Sometimes it requires more than one submission for various reasons, but it's very straightforward, and I am relentless, as Steve has said, that I will continue my follow-up until everything has been confirmed and taken care of. And then once all that is done, we know that your plan is going to work the way you wish for it to. That's all I have. Any questions? Okay, no questions.
No questions, Mary. Great job.
Thank you.
All right, Mary and I are socially distancing here in the office, so I'm getting my mask off. All right. Now, before I get Nicole on the call here, she's standing by, I just want to talk about one last thing. I'm just going to double check myself here very quickly. Yes. So I want to talk about assets under management. So there are opportunities in asset alignment, not only for best practices and taking care of people and taking care of yourselves if you're a client on the call here. There are opportunities in asset management. So financial advisors obviously want to increase their assets under management. And I want to just say that our process is designed that we want to reach out to you as a financial advisor and CPA if you're on the call, and we want to discuss the assets under management. We want you to come, generally speaking, with the client's permission. We want you to come to meetings. We want to meet with you. We want to understand your strategy for the client and work with you as a team, as I mentioned down below on this slide. And it's an opportunity. I have seen many financial advisor opportunities where they will refer a client to us, and we sit down with the client, and the client does not have all of their assets with that particular financial advisor. And that's up to the client, of course. But this is an opportunity to garner more assets under management or to show more value. And for clients that are sitting on the fence about certain assets that they know maybe should be managed, this is an opportunity to reconnect with your financial advisor, even though many of you financial advisors on the call have multiple meetings with your clients during the year, and you don't need this kind of meeting to connect with your client. But the point I'm trying to make is we want to provide the highest and best practice for the client and for the team. Second chances, asset alignment gives us a second chance and a third chance and a fourth chance to follow up, because would it surprise you if I told you that not all clients are responsive with asset alignment information, but many are wonderful and do a wonderful job to do that. So we want a second, third, and fourth chance to make sure that we are addressing the asset alignment over time as time goes by. I can't believe it's already towards the end of September already. Time does fly. For client retention and client value, there's nothing like asset alignment and the client care program approach to be able to give clients the kind of attention, the kind of follow-up, the kind of repetitious over the lifetime follow-up that they need to make the plan work and for them to understand the plan over time. And of course, there are opportunities for advisors, CPAs, to obtain new clients from having these close family relationships. And not only that, but to have assets under management for the next generation. And that all leads me to say, of course, we are very thankful for our advisory team opportunities with financial advisors and CPAs, and we want to be worthy partners in leading the way on best practices and working with you for the benefit of clients. Now, with that said, I'm going to turn over the presentation and I'm going to advance the slides for Nicole Livingston, who's on the call. And I'm very happy for you to hear from Nicole, who is just a wealth of information about the mechanics and other things that we're dealing with estate planning. Take it away, Nicole.
Thank you, Steve. So everyone is aware of COVID, and in March, it all changed the estate planning department temporarily. So when we were told about this stay-at-home order, we immediately had to cancel some of our signings that we've had scheduled. And why? Why did we have to do that? Well, the law in Maryland stated that we had to meet with clients in person to sign and execute your estate planning documents. So fortunately, it was a temporary hold pattern, and we received information, and I do have, I think, the next slide. I know, I'm sorry, Steve, you have the presentation in front of you and you need to advance the slides. So fortunately, we received some information on, the first date was on April 10th from the governor's office that allowed us to do some remote notarization. And then we received another order that allowed us to do witnessing remotely. So I'm going to talk today about what our process is here in the estate planning department here at Elville and Associates. And on the screen here, you can see our number one and most common way to sign your estate planning documents has been remotely, and we use Microsoft Teams. Second, not everyone has a computer, not everyone is as tech savvy as everyone it needs to be these days. So we meet clients safely in what we call our parking lot signings. So we do occasionally have those still in Columbia, and I've also met clients down in the Annapolis office to sign documents when you're safe in your car. And I have as a last resort. So, and we occasionally have in-person signings, and we do have the luxury of having the large conference room where Steve is right now that has a really large table, and we're able to do proper social distancing. I'd say a last resort because only recently have the numbers seem to have gone down here in Maryland, and we feel a little bit more comfortable and clients feel more comfortable about coming in person. So I want to talk a little bit more about just what I just said about the remote order. So Steve, the next slide, I believe, talks about that first order. And like I said, April 10th, 2020, the governor did finally issue this order that suspended the in-person requirement for us to sign. If you go to the next slide, Steve, it says that we suspended those in-person requirements to sign your last will and testament, the powers of attorney, and the advance directive. So that order is very important, and I'm going to mention it again in just a minute. So again, because we had the order that we were able to suspend the in-person witness requirements. Next slide. Here's the conditions that we were under. So the conditions to remotely witness the documents is that the witness needs to be in the electronic presence of the signer, and our witnesses have to be residents of Maryland. And the attorney cannot be the witness for the signing. We have to be what they call the supervising attorney. And what the supervising attorney's job is that we have to sign a certification of the entire process. So we certify that the entire event occurred and who attended it, and that we're all residents of Maryland. Next slide, Steve. So once we had our suspension of the in-person requirements, we needed also the suspension or not really the suspension, but the ability to do in-person notarization of the documents, because our powers of attorney do need to be notarized, our advance directives and so on. So we really also needed these two orders to work together. So actually this order came first. It was actually on March 30th that Governor Hogan waived those requirements and allowed us to do the remote notarization. So on the next slide, I have our requirements, and we had quite a few to be able to become a remote notary. So of course we had to be in good standing already. We already had to be a notary within the state of Maryland. We had to submit a form to the Secretary of State of our intent to use remote notarization. And we had to identify which vendor we were using. And if you can see there on number 6 at the time, if you recall, it seems like so long ago, but it was only in April that there were some issues with Zoom. So in the order, they specifically said we cannot use Zoom to do the remote notarization. So fortunately, our office, we already had Microsoft Teams set up, and it worked seamlessly. It just was actually just good timing, and Microsoft Teams was approved by the Secretary of State. The only condition is that we have to record that act. So we have to record it and save that recording. And again, once again, under Teams, it's very seamless, smooth to be able to record it and save it on our system. And we have the technology to do so. All right, and one next slide, Steve. So we got our orders. We could do we can do the remote notarization. We got the order that we could do the remote witnessing. So how do we pull it together? How do we sign the documents? So here's our procedure, our current procedure that we're using at Elville, and it works. It really does work seamlessly. It's a very easy process. It looks like a lot of steps, but we have been able to do this quite frequently since April. So we send a link to our client with who's signing the document, and a link to the paralegals and the attorneys, so we all join the Microsoft Teams meeting. We then mail the signature pages to the person who's signing the documents. And we have had a little bit of issues in the last month with the mail. Probably not a surprise for everyone who's following the news. And I can tell you we were doing at least 10 a week. So since April, we've had no issues at all with mailing documents to clients and for the documents to be received by them within a couple of days. And unfortunately, in the last couple of weeks, we have seen a little bit of a slowdown. So that's just something we're working on and keeping our eye on about how to handle. What we do then mail, again, the signature pages to the client, the signer, and then on the day of, you all join the meeting and we watch you sign the documents and we record that signing of the documents. Next step is just take all those documents that you just signed and we give you a postage prepaid envelope and you return the documents back to me. And then I need to notarize the same exact documents that you signed. That's what we call our wet signature. So every wet signature that you have in a document is where then I need it to also then notarize on my signature on that page. And I collect the documents from our paralegals, and then we package everything together and we return the originals back to you, the full packet. So it's so far working great. That's our process. We've been very pleased. Our clients have been very happy. Everyone feels very comfortable with this process and happy that they can actually sign their document. So then there's a next step. There's another slide. We have a possible wrinkle in our plans, and it might not be as big of a wrinkle as we originally thought. But the legislative session in 2019 passed a bill, and it was effective October, or it will be effective October 1st, 2020. And this is a bill that actually, the purpose of it was to allow remote online notarizations, which sounds exactly like what we're doing now, but it's different. When this bill was passed, I don't believe anybody had COVID in mind. They had no idea what was coming. And this particular bill really is just, it actually even states it wasn't to be the same thing as the order that was passed by the governor waiving the in-person requirements, because this bill says specifically that we are not allowed to use Microsoft Teams to do remote notarization. So if you go to the next slide, so it specifically states that you cannot even notarize wills, which we don't frequently notarize wills anyway, but it specifically states we cannot notarize revocable living trusts. So don't panic. So here, next slide, here's what our opinion is here at the firm. And it does lead me to believe that this new law is very different from the governor's order. The governor's order that temporarily allows us to do these remote notarizations during the COVID-19 state of emergency. His order specifically suspended all of the rules that we currently have, the statutes that said we have to sign legal documents in person. So again, the governor suspended those rules. So again, if you go to my next slide there, Steve, that's what the governor suspended it. So that's the most important thing. The COVID emergency hasn't changed. So we feel that the governor, who's the head of the state, his order is still in place. His order still states that all in-person notarization and witnessing of estate planning documents, all of that in-person requirements is suspended because the emergency order has not lifted. So based on that, we are seeking clarification from the Secretary of State to just again state that, yes, we have two different rules going on right now. We have the order from the governor that stayed the rules for in-person requirements and allows us to do online remote notarization. And we have this new rule or new statute that was passed that does allow different types of remote notarization. And I think more in line with real estate and closings and settlements is really what I think that order, the purpose of that order was that was passed during the legislative session. So again, just to give one more slide, I believe I have, or is that the last one? No. So that was it. I just wanted to say that we still feel that right now that we can continue signing documents with our clients using Microsoft Teams to remotely notarize the documents and witness the documents. And based on the governor's order, we feel that we still can do that. We are seeking clarification from the Secretary of State just so that they can clarify what their statement was that said that just regarding this new order for the remote notarization, and we want complete clarity for our clients. And we are working on that, and we will make sure that everything is in place for October when we do our remote signings then. Any questions about remotely signing documents? I thank you, Steve, for allowing me to join the presentation today and let everybody know how we are handling signings here at our office during COVID.
Thank you, Nicole. Fantastic job, as always, and very, very solid approach that Nicole and Olivia here have cultivated at our firm. And if you have any questions about or any reservations about needing to sign documents, how am I going to do it? Remember, we're here to do that. We're here to help review and update planning if we have asset alignment questions or other updates. Many of you have not come in for your Secure Act update, so we need to be reminded of that. And with that said, I'm going to say the sun just peaked out here in Columbia a few minutes ago. So I hope you have a wonderful weekend ahead. And Jeff, I'm going to turn it back to you.
Sure. Thank you, Steve. Let's give Steve, Nicole, and Mary a virtual hand for a job well done. We'd like to thank you for participating in our advisors forum today. And what I'll be doing is I'll send you out the video link for today if you'd like to share it with friends, family members, colleagues that couldn't attend today. Please keep in mind our November 11th advisors forum, which is one that you certainly won't want to miss. Also, we have many presentations coming up for the beginning of October and November. So please check out our events calendar on our website for more information about those, and I'll be sending some invitations out for those. So as Steve said, yes, please, we would look forward to being a resource to you if you're an advisor and we haven't met you. I'd love to reach out to you and set a time to get to know you. If we've worked with you and we haven't connected with you lately, I'll be reaching out with you as well. For clients or those that we haven't met yet, again, would love the chance to work with you and help you with your planning needs. So look forward to being a resource to you here at the firm. So the sun has peaked out. I'm not going to keep you from it. Hope you have a wonderful weekend, and thanks for being part of our advisors forum today. Have a great day, everyone.